Finally, we will tackle the important notion of hierarchy of norms, also known as the pyramid of norms, la pyramide des normes. This is a concept explained by Hans Kelsen. Hans Kelsen is an Austrian legal scholar who is also known for being the father of positivism. You may remember the theory of positivism when we discussed it along the theory of natural law. And we said that according to positivism, the criteria should be a formal criteria. Therefore, we do not discuss whether a law is just or no. We want to know if the legal rule is issued according to procedure and whether it is issued by competent authorities. Now, every rule then should be not only issued by a competent authority, but should also respect a hierarchy of norms. At the top of the pyramid, we have the Constitution, considered the higher norm. Why? Because the Constitution, if you want, we can compare it to the rules of the game. Right? These are the rules, the founding principles of the state. Everyone agrees on them and they are considered as a higher norm. It is possible to amend the Constitution and to modify the Constitution, but according to very difficult rules. So the Constitution is at the top, at the stool, meaning all inferior sources of law should respect the Constitution and be conform to the Constitution. Next, we have international agreements. International agreements, الاتفاقات الدولية, which can be multinational agreements, including many countries, or bilateral agreements between two countries. These international agreements, they will create duties on the state towards these other nations. After them, we have legislation, legislative acts, acts issued by the parliament, national laws, if you want. So these national laws are inferior to the Constitution. They should always respect and to the Constitution and be in conformity with the Constitution, but they should also be in conformity with international agreements. Under the legislative acts, we have the administrative acts or executive acts, acts by the executive branch. We already mentioned them, al-marasim, al-qararat, ila akhirih. These should be also in conformity with all the superior norms. So this pyramid allows legal practitioners and legal thinkers sometimes to find a solution when we have a contradiction. When we have a contradiction between two norms, the superior norm will always prevail. And if we have a contradiction between the Constitution and a national law, we should always prioritize the Constitution. And an inferior rule must always be in conformity with the superior rule. Now, what happens when we have a contradiction? What happens when we do have contradiction between norms of different levels? The Lebanese system includes institutions which mission is to actually settle these contradictions. For instance, if we have a law, a legislative act, which is contrary to the Constitution, we have an institution named the Constitutional Council, Al-Majlis al-Dusturi, which will look into the matter, and if the legislative act is indeed contrary to the Constitution, the Constitutional Council will annul it, will declare it void. The problem in Lebanon is the access to constitutional justice is rather limited. Citizens do not have direct access to the Constitutional Council. Only deputies, 10 deputies, the presidents, the 3 presidents, and religious leaders have access to the council, while we as normal citizens, we don't have such an access, and the access is limited in time, 15 days after the publication of the law in the official journal or official gazette. So constitutional justice in Lebanon is rather limited. Why? Because of the limited access to the Constitutional Council. Now what happens when we have an administrative act, such as a decree, marsum, for instance, contrary to a law, then we can go to the State Council, Majlis Shura al-Dawli, or Majlis Shura. State Council can either annul the administrative act, بيقدر يبطل العمل الإداري، يعني بيقدر يبطل المرسوم مثلا, or he can simply decide that it will not be applied in a specific case. Access to the State Council is broader than the access to the Constitutional Council, meaning citizens with an interest, with a legitimate interest, can always access the State Council.